Good afternoon, and welcome to the Employer Link webinar series presented by McAfee and Taft. My name is Brad Neese, Managing Editor of Employer Link. Today, our topic focuses on how to avoid pregnancy discrimination in the workplace. Congress initially addressed this issue in 1978 with the passage of the Pregnancy Discrimination Act. Since then, though, the waters have been muddied with the enactment of a myriad of other federal employment laws, like the Americans with Disabilities Act and the Family and Medical Leave Act. It's gotten so confusing that now the U.S. Supreme Court is set to weigh in on the matter later this session. Our presenters today will discuss this trending topic and what employers should do while they await the High Court's decision. Our presenters today are McAfee and Taft employment attorneys Kathy Neal and Courtney Brew. Both represent employers in all phases of labor and employment law, including litigation in state and federal courts, in arbitration proceedings, and before regulatory and administrative agencies. Much of their time is devoted to counseling employers on compliance with a broad range of state and federal employment laws and regulations, as well as educating management on best practices for avoiding disputes arising from the employer-employee relationship. Both are also frequent speakers and authors on workplace issues. So with those introductions, I'll now turn it over to you, Kathy.
Thank you, Brad. Good afternoon, everyone. This voice is Kathy Neal's. The one with the really bad Southern drawl is going to belong to Courtney Brew. And we really appreciate you guys joining us. We're here to give you a little bit of our thoughts on where we're headed in the pregnancy area, pregnancy in the workplace. And I thought a good place to start with that would be to talk a little bit about how we got here. So we're all familiar with, and I know most of our audience is probably consists of HR professionals, so we're all very familiar with Title VII, passed in 1964, which included the prohibition against discrimination on the basis of sex. Well, things kind of rocked along between 64 and 76, and I don't think there were a whole lot of surprises. Most people believed that pregnancy was a part of sex discrimination, and employers behaved themselves to the extent they could. But then in 76, we had the General Electric case versus Gilbert, which came as a surprise to everyone. And in that, the Supreme Court ruled that an employee disability benefits plan, which specifically excluded coverage for employees who were temporarily disabled because of pregnancy, did not constitute gender-based discrimination. When you read back that case in light of today, it is kind of a mystery how the court actually got there, and the reasoning is very tortured, but it all kind of boiled down as to whether or not that benefits plan was excluding pregnancy as on a pretextual basis for sex discrimination. Really doesn't make a whole lot of sense today, and it apparently didn't make a whole lot of sense back in 1976 because in response to it, Congress passed the Pregnancy Discrimination Act 2 years later. And the Pregnancy Discrimination Act, which you're going to hear us call the PDA, amended Title VII to prohibit employers who had 15 or more employees from discriminating against female employees or job applicants on the basis of pregnancy, childbirth, or related medical conditions. Now, as that all shakes out, the PDA will apply to the whole range of pre- and post-pregnancy. It's going to apply to hiring decisions. It will apply to how an employer handles an employee's working during her pregnancy. It will apply to pregnancy-related leave, events that occur pre- and post-birth, and the post-birth return to work. And one thing that we don't have listed here on this slide is, of course, it applies to harassment motivated by pregnancy or childbirth or some related medical condition. So insults or offensive pictures or name-calling, here's a helpful tip, don't call a pregnant woman Big Mama. So it will apply to things like that in the workplace to the extent that they arise to a hostile environment based on pregnancy. And the guiding principles of the PDA are, as an employer, you base your decisions on a pregnant individual's abilities and qualifications to perform the work. And you treat pregnant employees the same way that you treat other employees who are affected by temporary medical conditions. And with that, Courtney's going to talk a little bit about some of the nuances that arise out of the PDA.
Right. So let's talk about this. Let's talk about what will you see on a day-to-day basis that is implicated by the PDA. And I want to be very clear, we are not talking Family and Medical Leave Act right now. We're going to leave the FMLA world to Kathy to discuss a little bit down the road. So we are looking at how does the Pregnancy Discrimination Act apply to these very common scenarios, and only that act. We'll muddy the waters here in a little bit, but right now let's be clear. A pregnant employee has to be allowed to keep her job and to continue to perform her job as long as she's able to perform her job duties. Now, we're talking essential functions of the job. We talk in a lot of different contexts about, well, sometimes we have these really elaborate job descriptions, and they will define this job in a way that's not entirely accurate. It doesn't really look on paper about what it looks like when somebody's performing the job on a day-to-day basis. So we're talking essential duties. Anytime we refer to duties as we go through these nuances, we're talking about essential duties. So employers can't decide how a pregnant employee needs to treat her employment. You don't get to decide when the employee needs to take leave for childbirth. You don't get to decide how long an employee should take off before they come back. And Kathy and I were discussing this morning, you don't see policies that say these things. You won't see a written policy that says, when it starts to get close, we would prefer that you just go home and hang out for a little while. What we do tend to see, and what's really common, is coworker comments. So maybe your pregnant employee is working with a supervisor to sort of schedule return to work after the fact, and the supervisor may say something along the lines of, oh, you're going to take 12 weeks off, huh? Well, that's really going to be difficult for us. Or as we get close to the childbirth event, a supervisor may say something like, you look like you're struggling a little bit. How about you go ahead and take these next 2 weeks off? You could take FMLA leave for these next 2 weeks. Those kinds of occurrences are very common and very much prohibited by the PDA.
And while Courtney's right, we don't see employers with policies that are explicit like this. What we do see is employers that base decisions on assumptions or stereotypes about what a pregnant worker can or can't do. For example, we might have an employer that assigns a pregnant employee to do a job that involves fewer deadlines because the employer thinks that that's the stress or the fast pace that was required of that employee in a current job somehow may affect her health. So one thing that we as employers have to be careful of is letting our decisions be influenced by our perceptions and our beliefs about what a pregnant worker can and can't do.
Yeah, common theme, and we'll touch on that a lot as we go through the course of this hour. Now, what about the flip side of that? What if you have an employee whose pregnancy has actually prevented her from performing some of the essential duties of the job? What do you do then? And this is not a new concept. Accommodation is not a new thing. We've talked about it for a long time. But that's what you have to do here. You have to come up with some way, or at least consider whether there's some way to accommodate the different conditions or the different health issues that a pregnant employee is encountering at that point in time. Creativity is really the limit here. There's not a list of accommodations that you can go find. The EEOC doesn't make a list available to you. It really needs to be an individualized assessment. What is this person's job? What condition are they facing right now? And how can we make it work for them going forward? This is a very common analysis. What things can we provide? What things are not disruptive? What things are not overly expensive? And you need to do that. And you need to be a little proactive about that. You don't need to sit back and watch an employee struggle for a period of time before you start having this discussion. You need to be sort of ahead of the curve here.
And one of the modifications or the accommodations that you might make would be offering a pregnant employee a light duty task, a light duty position for a period of time. We're going to talk in a minute about Young versus UPS case that's on the agenda for the United States Supreme Court, and it makes a distinction between an employee with an on-the-job injury and a pregnant worker. We're not really talking about this here, but if you offer non-pregnant employees light-duty jobs when they're incapacitated in some form or fashion, then an accommodation for a pregnant worker would be that same type of light-duty position. But as you'll hear Courtney and I say several times today, that you're not required to provide preferential treatment to a pregnant worker. So let's assume that you're an employer that doesn't have a light-duty program at all. What do you do then, Courtney?
Well, if you don't have a light-duty program and you don't make light-duty assignments available to any of your employees for any reasons, then you certainly don't have an obligation to somehow create a light-duty position for a pregnant employee.
That would be preferential treatment.
That's exactly right. That's the type of preferential treatment that it's very clear you don't have to provide. Even in the latest EEOC guidance, which we'll talk about here in a little bit, they made it very clear that this is not preferential treatment. It's just treating a pregnant employee the same as you would someone dealing with a similar type of medical issue. You can't treat a female employee who has recently had a baby differently than employees dealing with other medical conditions. One thing that the guidance does a good job talking about is, hey, we're talking about an entire process here, and the PDA applies to every facet along the way. So someone who's contemplating getting pregnant, someone who's having difficulty getting pregnant and going through fertility treatments, someone who is pregnant, someone who has a child, and someone who returns to work after having a child and may have caregiving responsibilities, all of these different facets are covered under the PDA. And so you have to ensure similar treatment at each different phase of the game. So when you have someone returning back to a job after having given birth, there may be accommodation on the backside too. You may have to give accommodations for a short period of time, and if you've given accommodations to other workers, then those would be things that you would have to consider for a recently pregnant employee. One thing that's very clear and has always been very clear is you have to treat this pregnant employee as having been in the workplace for the entire period of time that they are out because of a pregnancy, because of childbirth, or because of a health condition that appears during the pregnancy. So to the extent that you have a seniority system in place, or this employee accrues different types of benefits based on term of service, it could be PTO, it could be retirement benefits, those things need to be treated as if they were there the entire time. The second that you ding somebody for being out of the workplace because of a pregnancy, and that has an impact on benefits that they can accrue, you have violated the PDA.
Well, what if I have just an attendance policy that applies to everyone in the workplace?
Sure, and that's not uncommon. I mean, Kathy and I see these from time to time. One thing that you see along these lines is a bonus policy that may reward people for perfect attendance. And that's a perfectly neutral policy. It's certainly not written or drafted in a way that makes you realize it has an unfair impact on a pregnant employee, but it may have an impact, and it may have, what we call a disparate impact, meaning that it will impact one class of employees differently than others. Your pregnant employees, your women that go out on leave after having a baby will be impacted by that, and so you really run the risk of those being found unlawful. You really run the risk of violations of the PDA. One thing that we tend not to think about is what about employees who may have had abortions or employees who may have abortions during their employment. The Pregnancy Discrimination Act, and especially the guidance, is clear that we can't discriminate against women based on those decisions. We've already discussed provide maternity leave. There is no federal law that says you have to have a maternity leave policy. If you have one, that's fine. Many states require it. Other states don't. But if you do have a maternity leave policy, it can be paid or unpaid, and that's something we were kind of chuckling about this morning is, there's still this perception out there among your workforce that leave because of pregnancy or childbirth is paid leave. And that's simply not the case. We're talking unpaid leave. Any time that the federal or state law sets a bar, you're free to go above it, which means if you choose to provide a paid maternity leave policy, you're free to do so. You're simply not required to do it.
And as Courtney mentioned earlier, one thing that the EEOC guidance does make clear is that an employee who intends to have children but is not pregnant is protected by the PDA. So if you're a supervisor and an employee comes to you and says, I'm so excited, my husband and I made the decision that we're going to try to have kids, and you say, termination, that's a problem. Okay?
Yeah. And that's a really common occurrence. I mean, the thing that's unique about pregnancy that may not be as as available or as applicable when you're talking about other medical conditions is at some point it becomes visible, right? at some point the word is out and people know, what's going on and what's on the horizon. And there's so you could have a advisor that I'm thinking about having a family, or, hey, I'm pregnant, or it becomes apparent to your supervisor at some point in time. And timing is very important. When do you have notice, and when are you making employment decisions that could potentially impact the PDA? You'll hear us talk about that as we continue to go today, but those are two concepts to consider and sort of always be aware of. What did you know and when did you know it?
Another thing that I don't think this comes up much anymore, but it was the subject of a lot of litigation early on, was when employers who are in kind of the heavy type industrial or manufacturing industries, some of them had policies that restricted women from certain jobs, ostensibly because they were concerned about the exposure of, say, a fertile woman to harmful chemicals. And these type of sex-specific restrictions are very nearly always in violation of the Pregnancy Discrimination Act.
I honestly can't imagine one that would pass muster. The case that Kathy sort of references there was an employer that made batteries.
Yeah.
And so there were some pretty serious chemicals involved in that process. And the employer was very candid and upfront that they would not hire women who were fertile, who were of childbearing age, to work certain positions. And they eventually found themselves in a lawsuit about that. And one thing that's interesting about that suit is there was never any real discussion that there wasn't some type of connection there. No one really challenged the science. I think everybody was willing to say there are some really heavy chemicals here. They could have a really serious impact on a woman's ability to get pregnant and have children. But what the court said was, it's not the employers. People weigh for themselves whether they want to subject themselves to the risk. Those are the types of stereotypes and assumptions that are off limits here, that you just can't do. Really interesting case, and the industry there was such that if that doesn't work, I can't imagine anyone else coming up with anything that could do it.
Let me go off on a little side jaunt here, but sometimes you are influenced inappropriately by the views of coworkers and other employees. And so a situation, let's assume this kind of fact situation. We have a female pregnant worker who has a restriction on lifting greater than 20 pounds. And she's in a position where the essential functions require her to lift more than 20 pounds occasionally. Now, this is not the first time that this employer has had an employee with lifting restrictions. It's fairly frequent for this employer. So that what they've generally done in the past is they've accommodated this by having other employees assist with the lifting part that the restrictions cover. And so that's their intent, in my example here, of how they're going to handle the pregnant workers' lifting restriction. But coworkers are mad. For whatever reason, they were happy to do this for John, but they are not going to be happy to do it for Joanna. And they come to the supervisor and they say, we don't want to do this. We have to pitch in. This is an additional burden on us. It interferes with our productivity, and we don't want you to put us in this situation. How do you handle a situation like that?
You turn a deaf ear to it. You absolutely cannot listen to coworker complaints or grumbles. The duty that's on you to accommodate is imposed on you by federal law, and sure, it may have some impact on others. And you could be in a situation where they've had to sub in multiple times for this same employee as she builds a family, and you absolutely cannot allow that to have any impact on the accommodation that you decide to provide. That's just a red herring, 100% irrelevant.
That's why I throw it out there.
All right, so we're talking PDA, and we're trying to be very clear here what we're talking and what we're not. We're not talking Americans with Disabilities Act. We're not talking FMLA. So it does not matter how long a particular employee has been with you for her to have protection and to have rights under the PDA. And also, let's talk a little bit about health insurance. I think this is probably getting a little more play over the last couple of years as we've dealt with the Affordable Care Act, but this is actually not new. Any health insurance that you provide has to cover pregnancy-related expenses on the same basis and in the same amount as they would cover costs of other medical conditions. There was a time where it was common for an insurance plan to only cover, 60% of this pregnancy-related condition and cover 100% of a similar condition that requires similar care. Those days are gone or should be gone. I think you'd be hard-pressed to find a plan now that allows for that. And that's a long-standing thing. That is not an Obamacare baby. That's something that's been around for a long time. Also, you cannot provide a different level of coverage to different spouses of different sexes. So if you provide spousal coverage to a female employee for her husband, you have to provide the same type of coverage for a male employee's female spouse, despite the fact that she may come at you with additional claims for benefits because of a pregnancy or pregnancy-related conditions. These things seem commonplace now, but these things were litigated about.
Right.
It took a long time to get to these different principles. And one thing that we'll talk about a little bit, the EEOC's guidance, one thing that we know is not okay is if we have a policy, a written policy, that denies pregnancy leave or denies sick leave during the first year of employment, but would allow for leave for other types of conditions, that's discriminatory. So it's not uncommon for us to have probationary-type policies where an employee can't take leave, any kind of leave, vacation, PTO, sick leave. You can't take it for the first 90 days, or you can't take it for the first 6 months. And surely the purpose of that policy is obvious. You don't want to hire someone and then they're immediately gone. And they're never written in terms of impacting pregnant employees. But the EEOC has made it very clear that they will target those policies. If you have a neutral probationary type policy that does not allow an employee to take leave for a certain period of time, and then an employee is pregnant, has a childbirth event, or has a pregnancy-related condition and needs to take leave, you need to set that policy aside. You need to make an exception there for a pregnant employee, or you're really at risk of the EEOC coming at you for a PDA violation.
But okay, well, I'm going to play the devil's advocate here. So I have a policy that I enforce no matter whether or not it's a pregnant worker or it's a male. And let's assume I have a male worker who hasn't met the length of service requirement, and he has a heart attack. And I don't let him have any time off. I don't have policies that require me to do that. I'm not an FMLA covered employer. So if I've treated him in that manner and a pregnant woman needs to take leave, am I at risk?
You could treat her in the same manner without being at risk. Because one thing we know is the PDA does not require preferential treatment. Sometimes I always try to be in the office on Friday afternoons because sometimes there's a lot of phone calls that you get on Friday afternoons, and we all know what that means. And I like to be there for those. And one thing we talk about during those conversations is, if I do this, if I react this way or not this way, do I create some type of a precedent? I find myself having a lot of precedent-type conversations. Well, this is somewhere where, yes, you are creating precedent. So if you have a male employee that suffers from a certain condition and you give that person some type of accommodation, or you allow that person to take leave, you allow that person to take leave even though they fall within some type of probationary policy and they're not entitled to leave, you have created a precedent, and you must allow a pregnant employee to have that same advantage, to have that same benefit going forward. All right, so we've talked about, we cover all the phases. So what happens after childbirth? What happens when you have an employee that's now coming back into the workplace? And this can be difficult. This can be a tough situation for a lot of different reasons. You have to treat the returning previously pregnant employee the same way that it treats other employees who have been away or haven't been able to do their jobs for a short period of time. So Kathy and I are going to talk a lot today about the male heart attack victim. And it's just easy. It's not personal. Yeah. It's just a really easy contrast. So here's an example. You have the male heart attack victim that goes out on some type of leave, paid or unpaid. It really doesn't matter. You have to offer that same arrangement to an employee with an unrelated need, a need not related to the fact she had a heart attack, but because she's pregnant or she's suffering from some type of condition. You have to offer the same arrangement. If you offer the male heart attack victim some type of leave and you hold the job open for that person, and he comes back, days, weeks later, pregnant employees. So precedent
who are similarly situated.
And that's all that's allowed, all that's required under the PDA is treating everyone the same.
Okay, so let's talk about, and we're all kind of excited about the Young versus UPS case because, it's going to directly impact a lot of our jobs, and it's interesting in light of the EEOC's guidance. But Ms. Young, who was a UPS driver, ended up getting pregnant, but the essential functions for the UPS drivers included an ability to lift, lower, push, and pull packages weighing up to 70 pounds, and they had to assist in moving packages weighing up to 150 pounds. So this was what she was expected to do as a UPS driver. Now, UPS had a collective bargaining agreement that required it to provide light-duty jobs to employees who had been injured on the job or who had a permanent impairment that was cognizable under the Americans with Disabilities Act, or those drivers who had somehow lost their DOT certification for driving. So clearly under the UPS policy and under the collective bargaining agreement of UPS, a pregnant employee could continue to work as long as she could perform the essential functions of the job. But under those policies, she was ineligible for light duty with respect to any limitations that might have arisen as a result of her pregnancy. So Ms. Young had undergone a couple of rounds of in vitro fertilization, and she ended up pregnant. She ended up also with a doctor's note that restricted her from lifting more than 20 pounds during certain parts of her pregnancy and more than 10 in the latter parts of her pregnancy. So she wanted to continue to work, and actually she'd been out on leave, so she wanted to come back to work. And UPS said, no, we don't have any light duty positions available for you to work. And clearly the court found that UPS was basing this decision solely upon those lifting restrictions that had been imposed by her physician as a result of her pregnancy. She files an EEOC charge. She has several different claims. She claims race discrimination, sex discrimination, discrimination on the basis of her pregnancy, and she claims that also she had been discriminated on the basis of a disability under the Americans with Disabilities Act. So the court ultimately the district court granted summary judgment to her. So this goes up on appeal to the Fourth Circuit Court of Appeals. And they say you're not disabled. A normal pregnancy is not a disability. And we're going to talk a little bit about that as well. And then they turn to whether or not she's been the victim of pregnancy discrimination. And the court specifically finds that the UPS policy is pregnancy blind. The court cites a couple of other cases, and these cases are interesting. They say that the Pregnancy Discrimination Act does not require employers to take steps to make it easier for pregnant employees to work. An employer can treat a pregnant woman as badly as it treats similarly affected but not pregnant employees. So the court looked at this and said, if we adopt Ms. Young's position that she's entitled because of her pregnancy to a light-duty job, we would be requiring employers to provide light-duty jobs to pregnant employees whose restrictions arise from an off-the-job event. Now, presumably, that pregnancy arose from an off-the-job event. I think we have a completely different situation here. But we're going to be requiring employers to treat employees whose restrictions arise from an off-the-job event while denying accommodation to an employee who is unable to lift as a result of an off-the-job injury or illness. So basically what Ms. Young was advocating is that I'm the same as a disabled employee under the ADA, and I should be accommodated in that manner. The court said, let's contrast this. Let's contrast this to an employee who, say, injured his back while he was picking up his infant child and has a lifting restriction, or an employee who injured her back because she's a volunteer firefighter on the weekends. Both of those situations under this policy would be ineligible for an accommodation, yet Ms. Young is asking us for an accommodation because of a similar off-the-job type injury. So basically the court said she's not, she is demanding preferential treatment. That is not required by the PDA. And where a policy treats pregnant workers and non-pregnant workers alike, the employer has complied with the PDA. So very interesting. And probably, I'll ask you, Courtney, what do you think about that opinion?
I think if you look at the law and the case law that exists as the time that the Fourth Circuit decided Young, that's the outcome that you would expect.
I agree with that.
I think the problem is, and you mentioned it, there are several different claims presented in Young. And, we're trying to distinguish in this presentation between PDA, ADA, maybe even FMLA. And in Young, we have two of those claims side by side. And I don't care what form you're in or what lawyer you are, when you're working on PDA and ADA issues side by side, they mingle a little bit. And I really think that what's going on here is more ADA related. It's interesting because I think there's some tension that stems back to the Amendments Act, to the Americans with Disabilities Act. And we all know things got easier. There are more disabilities. The analysis changes a little bit. Things are just broader now when we're talking about employees with disabilities. And one thing that we know from the Amendments Act is that a condition that's transitory and minor, those aren't my words, I don't talk like that, but conditions that are transitory and minor, and the rule of thumb there is 6 months or less, that those are not considered disabilities. And we know that the condition of pregnancy in and of itself is not a disability under the Americans with Disabilities Act. And we know that the cause of a condition is something that we're not supposed to consider under the Americans with Disabilities Act. And I think we have all of those concepts that are really the meat of Young. I expect the court will probably resolve the PDA issue pretty quick and then move on to some ADA issues and resolve some things under the ADA. But
and that may be why the Supreme Court accepted cert on Young. Because, Courtney and I were talking about this early. We know what the ADA says the standards are for disability. And we know that a normal pregnancy is not considered a disability. But there are many things that arise in the context of a pregnancy that are transitory. Morning sickness. The EEOC actually goes to great lengths in its guidance to talk about things within a pregnancy that could be considered disabilities, like some sort of a disorder of the uterus or cervix that requires bed rest to carry a child to full term. They mentioned pregnancy-related sciatica, gestational diabetes, or preeclampsia. Well, the EEOC clearly considers those all to be disabilities under the ADA. Yet, as far as I know, these things resolve themselves when the pregnancy is over. So they are kind of in and of themselves transitory.
Right. They're temporary conditions. May not feel like it at the time.
Yeah.
It will pass.
Yeah. Well, interestingly, within about, I think it was a week of the Supreme Court deciding that it would accept cert on the Young case, the EEOC issued these enforcement guidelines on July 14th, just this past summer. And it was sort of a, in your face, because particularly with respect to pregnant employees being entitled to light duty positions, the guidance from the EEOC is absolutely 100% contrary to the ruling of the Supreme Court or the Fourth Circuit in the Young case. And we all know that these are guidance. These guidelines are intended to guide us. They are not the law. They are sometimes followed by courts. Sometimes they're not. They are generally entitled to some deference, and courts will provide some deference to them. But the EEOC specifically says that an employer can't lawfully deny or restrict light duty based on the source of a pregnant employee's limitation, i.e., an off-the-job event. An employer has got to provide light duty for a pregnant worker on the same terms that light duty is offered to employees who are injured on the job, who are similar to the pregnant worker in their ability or inability to work. So it is like, boom, take it. Right. Take it, Supreme Court.
And it's interesting, that when the PDA was first enacted, if there's a new law, it takes the EEOC some time to create some guidelines, to create the fact sheets that they have available for us, and to roll those out. And so it did that in the years following the enactment of the PDA. And this is the first time that they have revisited that since. So we got new guidance for the first time in more than 30 years, and it came kind of out of the blue. You'll usually see announcements that the EEOC is working on new guidelines, or somebody will leak that we can expect new guidelines, and there really wasn't much of that here. And then boom, here they are. I think the motive is pretty clear. The guidelines didn't really contain anything other than this light duty discussion, but there really wasn't anything in there that kind of jumped out at me as being, well, this is a radical departure. I think they had to catch up on 30 years worth of case law, and so they look drastically different and say drastically more than they did the first time around, but there really wasn't anything new. One thing that they do spend a decent amount of time pointing out is that we cover all aspects of all facets, all stages of a pregnancy, before pregnancy and post-pregnancy, and then they really put some scary language in there about looking at these neutral leave policies and targeting these neutral leave policies. So I'm thinking that, and I could be completely wrong on this, but I'm with you. I think the Supreme Court will deal with this pregnancy thing pretty easily and young. But the bigger question is a pregnancy, is just a simple pregnancy with no complications, is it really going to be viewed as a disability under the ADA? That's certainly the EEOC goal. I think you have to acknowledge that based on their guidance. I think and they want to read out the cause of a condition, and they're borrowing from the ADA to do that in an act that doesn't contain the same type of language. Right. So it'll be interesting.
It is going to be interesting. Just a quick note about pregnancy discrimination lawsuits. They're never really easy because they get all tangled up. Timing gets tangled up with decisions made in the office. I thought just for you guys, I would give you some of the facts about an HR specialist in Kansas who was pregnant and believed she was a victim of pregnancy discrimination. She was offered a job. Her name was Mary Brown, and she was offered a job when she was about 3 months pregnant. And before accepting the position, she sent an email to the HR supervisor who had extended the offer to her. The email informed the HR supervisor that she was pregnant, gave the estimated dates of her maternity leave, and stated that she wouldn't feel comfortable accepting the job if it was going to somehow inconvenience the department. Well, of course, the busy season for this particular company was exactly the time that she was going to be off on maternity leave. And nobody responded to the email, and her deadline to accept the job was the next day. So she accepts the job the next day on her deadline, and nobody has responded at all on this email. So she starts training, and the idea is that they're going to put her in a particular region, and she's going to be an HR specialist in a particular region. She starts the training. About a month after she starts training, there's some deficiencies in her performance noted between two of the supervisors. Nobody shares them with her, but there are things like the fact that during her training, she doesn't take very many notes, and she repeatedly asks questions about the same basic process, and she didn't seem to be receptive to the manner in which they were training her. Well, the next month, there was a meeting to discuss her individual development plan for the coming year, and something happens in this meeting where there's something to the effect of, you're not going to be here during the busy season job. Now, it sounds like that can be taken completely out of context. It's not exactly a smoking gun, but it did concern the court. In the context of what happened to her then, 3 days later, they call her in and tell her there are some concerns about the training progress that she's making. They follow up with an email that criticizes her for being indifferent to the training process and resistant to the company way. And then, a few days later, she gets complimented by another group of HR for doing a good job on assignment, and then another compliment comes in for the manner in which she completed a more complex assignment. So she's being criticized yet complimented, and a week later they terminate her. And by that time, she's 6 months pregnant and showing. So her position was, the company didn't really want me to take the job once they learned I was pregnant. They sought to sabotage my training. Company says she wasn't progressing satisfactorily. And the court says, yeah, I hear what you're saying, but you fired her 2 weeks after this conversation in which a supervisor expressed some aggravation with her because she's not going to be there, and right on the heels of some people complimenting her. So the judge let this go to a jury. Jury found in the employee's favor. It was a $75,000 verdict. But the judge said, these inconsistencies are, the jury has the right to determine whether or not these are evidence of pretext. So, like many of these cases, the timing is critical. When an employer finds out about the pregnancy of an employee is critical. And in this one, the timing just seemed to work against the employer. It's I think it's typical of the cases that we see. There's really no cut or dried one side or the other as a general rule.
Yeah, they're difficult, and that makes the cases last longer. It makes the cases harder to win, makes them harder to win early. I have a case right now, and one thing that has struck me, there's a pregnancy discrimination claim, is that, pregnancy is different than these other protected classes because it's there and it's exciting and people can see it, and so it's talked about much more. You ask somebody how they're doing, or in this case, there was a shower in the office, so people are talking about the pregnancy, and it's very much there and in the front of everybody's minds, not the same way that you sit around and have a water cooler conversation with someone about, oh, wow, you're male, that's really exciting and interesting. It's different than the other protected classes, and so it's talked about more, which creates more evidence, which creates more inconsistent comments, which creates a broader inference that this was a big deal for people. So they're tough cases. They're tough cases to handle. The Affordable Care Act does have a limited impact on your pregnant employees, and that is that it requires an employer to provide reasonable break time so that nursing mothers can basically take care of lactation needs. And this is, again, another aspect of returning to work after pregnancy that would be protected under the PDA, but here we have some really strict and new guidelines. One thing is you have to do it. The only way that you may not have to do it is if you have 50 or less employees, and it would cause you some type of undue hardship to allow this. Let me tell you, that's a really high burden. You don't want to find yourself in court resting your entire case on the fact that it was a really undue burden to allow someone 15 minutes during the course of the day to take a nursing break. It also gives us some pretty strict guidelines on what this should look like and how it should work. We get to do this for a year. We know that. We know that the employer doesn't get to dictate when this happens. The employee gets to decide when is the break time, when do I need the break. And we know that there has to be a private place, not a bathroom, that can be used for this purpose. So in terms of federal law, some pretty black and white sort of bullet points about how to go about providing this.
So let's turn now. Everything we've talked about has been in the context of an employer not covered by the FMLA. And I know that many of you know the FMLA frontwards and backwards, but just very quickly, again, it only applies to an employer with at least 50 workers in a 75-mile radius. Doesn't apply to state, local government employers, and it provides 12 weeks of unpaid leave per year. I am always stunned when I do training at how employees seem to think they get 12 weeks paid leave per year under the FMLA, and they're shocked when they learn that it's unpaid. So it is going to apply to eligible new mothers and fathers who have worked at least 12 months, and that doesn't have to be consecutively, and who have worked at least 1,250 hours over the past 12 months. So it impacts pregnant and new parents in several ways. If you as an employer are subject to the FMLA, you've got to provide FMLA benefits during a pregnancy where the employee has some sort of a serious health condition as a result of complications. And time taken off for the pregnancy complication can be counted against the 12 weeks of the FMLA leave for childbirth. You have to provide the FMLA leave when someone is, and this is male or female, a new father or mother who are taking care of a newborn baby, who have adopted a child or have a foster child. You can always require the employees to use up all their vacation, their sick leave, and their PTO first, and personal leave time, and that can all be deducted from the 12 weeks of FMLA leave, concurrent running. You also, as an employer, have to provide leave for an employee to care for a spouse or a child with a serious health condition. If you have an employee whose wife has a serious health condition, then you have to provide that leave for the husband to care for the wife. Or if subsequent to the birth there's a child with a serious health condition, then they would have FMLA rights there. With respect to childbirth, however, if a father and a mother both work for the same employer, they only get that combined total of 12 weeks of FMLA leave for childbirth. Now, if time is taken off for prenatal care or pregnancy complications or to care for a sick child, something that is a serious health condition, that is not subject to the combined limit for the maternity and paternity leave. And, of course, under the FMLA, you've got to reinstate a parent who returns from leave to the same or equivalent position. The only exception to that would be where you have a 10% of the highest wage earner, and you can show somehow that this would cause significant financial harm to put the person back to work. So under the FMLA, and with respect to how that might impact a new parent or a pregnant employee, you've got to maintain the existing level of health coverage under a group plan during FMLA leave, although the employee has to pay his or her share of the premium. So obviously you can't discriminate against an employee for taking that FMLA leave, and you've got to provide the same kind of benefits normally provided to an employee with the same level of status. So that's a quick down and dirty on the FMLA.
And we also implicate the Americans with Disabilities Act here. So we said it multiple times. The EEOC says it multiple times. It feels easy to forget at this point, but a normal pregnancy is not considered a disability under the ADA. Nothing has changed that. A pregnancy-related impairment may be a disability if it substantially limits one or more major life activities. And remember, major life activities can be, I would say they can be verbs or they can be things. So things like standing, walking, sitting, lifting, those can be impairments of major life activities. But under the Amendments Act, we also have this new, and frankly, I think kind of a weird concept, that any impairment of a body system or a muscular system can also be a disability. So an issue with the digestive tract may be a disability. A nervous disorder may be a disability. Remember, the focus under the amended ADA is not necessarily whether something is a disability, but what do we do to address this something? So if your focus in the past has been yes or no, is that a disability? Your focus now needs to be, okay, well, what do I do if someone has some type of health issue? How do I move forward from there? And, with respect to pregnancy in the workplace, don't forget that there is a category for people who are regarded as having disabilities and for people who have a record of disabilities, and they are protected by the ADA as well. So if you assign a pregnant employee to a lower level, lower stress job because you think that there's some pregnancy complications and it would just be better for the employee to be in something that's lower level, lower stress, well, you've just regarded that pregnant worker as having a disability. And if you, for example, deny a job to an employee who, let's say the employee's been pregnant twice and both times has had preeclampsia, and that employee just now told you that she's pregnant with her third child, and you just assume she's going to have preeclampsia, then that employee may be regarded as having a disability, but also you're treating that employee as having a record of a disability. So those two areas also get swept up into no-nos under the ADA. And remember your obligations there. I mean, your obligations are to have an interactive discussion with the employee, to sit down and talk about, even within the course of a pregnancy, you may know the employee is pregnant, but you may not have a lot of information about what exactly the employee is dealing with at a particular point in time. And your obligation is to have a conversation and talk about that. And as part of that conversation, to talk about what are the potential accommodations that could help you perform your essential job duties despite this condition. I always like to advise people, get some suggestions from the employee about what types of things. I mean, they're the ones experiencing the condition. They can tell you firsthand what it is that I'm struggling with and what it is that I think I may need to be able to continue to perform the essential duties, and then be creative. Nothing's really off limits here. And remember your precedent. What have you afforded in the past? What did you give the guy that had the heart attack? That needs to be possibly something you consider as a reasonable accommodation here. And depending on what happens with the young case, one thing to consider may be,
is there light duty?
Light duty assignment. Not only do you have them, do you have to create one? And we'll have to wait and see how that shakes out. One thing I do want to talk about quickly, because I get a lot of questions about it, in the context of mixing the FMLA and the ADA. Sometimes, whether it's a pregnant condition or not, sometimes people can use all of their FMLA leave and still need a little bit of time before they come back to work. And I think we all have a tendency to just be real rigid about the 12 weeks. And I gave you the 12 weeks, and now it's exhausted, and so I get to make a real easy black and white decision. One thing it's really clear under the case law is you may need to consider under the ADA whether a little bit of additional leave is something that you can accommodate. So please keep that in mind.
Now, we're going to talk a little bit about hiring no-nos, and we kind of got to giggling about some of our questions here, but they come up. Courtney's had a recent experience.
I would say in the last 3 months, in an unrelated issue, I got all the documentation to look at for evidence in a different type of case. And one of the pieces of evidence I got was the particular employee, and it was a male employee's job application. And the job application was old. You could tell it was very old. It was obviously typewritten. It was very old. And as you were filling it out, right in the middle of the page was, are you currently pregnant? And a box to check for yes and a box to check for no. And I just about died. I could not believe that was there. It is a heavy industry type position, but it was there right in the middle. And so I picked up the phone and we had a quick conversation about your brand new job application that I'll be providing you in the next 5 minutes. So they still come up from time to time, and none of these things are per se illegal.
Yeah. Are you married? Are you single? It seems weird to think that someone might say, are you using birth control? But when I graduated from law school back in the days of when the earth was cooling, I was kind of a novelty as a female in the law profession, and people would come back from job interviews and they were asked, are you using birth control? And we'd just be appalled by that. But these are not illegal. These questions are not illegal. The EEOC makes this clear, but what the EEOC also makes clear is that in the event you get sued or they investigate you because someone has filed a charge, this is going to be the prima facie evidence of your intent to discriminate against a pregnant worker.
That's right. Notice and timing. Notice and timing. And all of this is just you gathering up all of the information that could be evidence against you down the road. I mean, I'm not sure I've ever been through a job interview where I haven't been asked, just try to get to know someone. Are you married? What does your husband do? Do you guys have a family? All of that is putting information on your plate that could be used down the road. Another thing that I do see from time to time on job applications is, do you have any reason or is there anything that you will need in terms of like a flexible schedule? Will you need a flexible schedule? Do you need to work certain hours? And it's always fill in the blank type things. And it's not uncommon for an applicant to fill that blank in with, I have 3 kids. If the babysitter doesn't show up or if there's a school event, I'm going to need time off for that. Well, yay, look at all this information that you now have about this person's either pregnancy or child care activities.
As a follow-on, we thought we'd talk a little bit about discriminating against workers with caregiving responsibilities. This applies to both men and women because men and women juggle work and their caregiving responsibilities, and it applies not only to children, but many of us have older family members or parents, a relative with a disability. Sometimes people have spouses that they have to provide care to. So while it's not exactly pregnancy, it does fall under sex discrimination under Title VII, primarily because the statistics show that women, and particularly women of color, remain likely to exercise those duties as a majority. So what you have to be careful about with respect to caregivers is that you're not influenced by misperceptions or stereotypes, and that those don't become the motivation for your employment decisions when you're dealing with caregiver issues, because that could all end up being sex discrimination under Title VII. But we've got some stereotyping and biases here, and some no-nos regarding caregivers. And Brad, do I have time to kind of go into this? Okay. So avoid things like assuming that a female worker's caretaking responsibilities are going to interfere with their ability to succeed, or that somehow a female worker who is a part-time or flex-time worker is somehow less committed to her job. A lot of people think, rightly or wrongly, that male workers shouldn't have caregiving responsibilities. But don't forget that FMLA allows for parental leave, or if you as an employer provide for parental leave, don't discourage male employees from taking it. If you have it as a benefit, expect that male employees will take that. Don't assume that female workers prefer, or perhaps should prefer, to spend time with their families rather than work. Don't presume that female workers who are caregivers are less somehow than capable than other employees, or that they're somehow less reliable than others. Be careful, of course, not to make the stereotypical comments about pregnant workers or female caregivers. Treat them the same way as you would female workers or male workers who don't have caregiving responsibilities. Don't try to steer women with those responsibilities as less prestigious or somehow lower paid positions. And treat your male workers with those kinds of responsibilities the same as female workers with those kinds of responsibilities. So that's it for us today on the Pregnancy Discrimination Act and handling pregnancy in the workplace. We appreciate your participation with us here today and hope that you guys have a good afternoon.
I want to thank Kathy Neal and Courtney Brew for presenting today's webinar. And on behalf of the law firm of McAfee & Taft, thank you for joining us for another Employer Link webinar. See you next time and have a great afternoon.